There exists some resentment by Māori as to the way we have been treated in the past, and this has coloured the way some perceive the current settlement process. It's important we maintain clarity of thought so as to best leverage the situation before us. Generations of effort has resulted in the Crown's attempt to reconcile with us, and it is up to us to advance Ngapuhi with the advantages that a meaningful settlement can offer. That being said, it's important to mention a critical concept that has been argued extensively in our tribunal hearings to date, and that is the difference in translation of Te Tiriti o Waitangi, written in Māori, and the Treaty of Waitangi, written in English. Our prosecution teams have without a doubt proven that Ngapuhi could never have ceded our mana, sovereignty, or tino rangatiratanga when it was we signed a treaty agreement with the Crown. It's expected that in its final report, the Waitangi Tribunal will confirm our position and formally record the true account of our historical dealings with the Crown. It should be expected corrections will be reflected through the proper legislative channels, and that our settlement team will also resolve any confusion the Crown has previously had as to the rights and position of Ngapuhi. Before looking at the advantages a settlement can bring for Ngapuhi, it's helpful to address common ideas discussed amongst those concerned with the settlement process. These issues include the fear that settling damages with the Crown brings with it hidden clauses preventing us from seeking redress for any future breaches of the treaty, particularly regarding our rights under international law in relation to such agreements as the TPPA. Generally, these concerns have been linked to suspicion that settlement clauses may extinguish the natural rights of Ngapuhi and allow the exploitation of our region's natural assets, an activity thought to be high on the agenda of select multinational corporations. Tied with this thought, another perception some maintain is that the Crown has used divisive practices to fast-track their own agenda by enticing individuals amongst us to hasten the settlement process, thereby weakening our potential to analyse settlement clauses and negotiate from a dominant position. Some feel this anxiety has been caused by our failure to work together as a full collective. It's feared by some that the Crown's intention is to lock down the sovereignty rights of Ngapuhi, and that it has forwarded this agenda by divisive means. The thought has been expressed by some that the way the Crown has awarded the mandated authority, that is the right for a group to speak and negotiate on behalf of Ngapuhi, has been done in such a way to handicap our united voice. The Crown has been accused of undermining our collective nature and allowing an unfairly advantaged minority to lead us into binding settlement conditions without the full support of Ngapuhi, a minority which potentially can be more easily swayed by government pressure and influenced behind closed doors. This has been a concern shared by some groups of Māori in past settlements. So are we in danger of this happening with Ngapuhi? To answer that, we should take a brief look at our mandated settlement body, Tūhorunuku. On the 14th of February 2014, the Crown recognised a mandate claimed by the group Tūhorunuku. The purpose of the mandate was to allow a negotiation team formed by Tūhorunuku to begin direct negotiations with the Crown for all historical grievances of Ngapuhi. In announcing the group's intention to obtain a mandate some years earlier, some claimant groups became frustrated because they were as yet unsure or unprepared as to how they would eventually negotiate with the Crown. Some claimants insisted the tribunal hearings process should be concluded before entering in the negotiation stage. Some groups also wanted to negotiate individually and still do so, yet in the current situation cannot. To obtain a Crown-recognised mandate and form what is known as an Independent Mandated Authority, or IMA, a vote must be conducted with participation from a reasonable percentage of the beneficiaries involved. From that vote, a consensus must be had. In 2011, the group known as Tūhorunuku completed the formal process of publicly notifying Ngapuhi that they intended to forge our negotiation team. As explained, to some, Tūhorunuku was seen as a premature settlement initiative that could have potentially cut short our Waitangi Tribunal hearing efforts. After much negotiation with the Crown, opposing claimant groups secured guarantees that a dual process was possible, of hearings and negotiations continuing simultaneously, a duality that some feel is an impossible fit, but a concession the Crown has made between claimant groups and our IMA nonetheless. Reservations are also held that the fractured relationship between the IMA and some claimant groups has left rifts of communication, where it's questionable whether meaningful dialogue can take place between those forwarding our claims and those that will be at the table negotiating settlement for these claims. The IMA was originally conceived by Te Runanga Aiwi o Ngapuhi, or Trayon, a legal entity created to manage the fisheries settlement of roughly half the marae within Ngapuhi. It is the largest current Ngapuhi iwi holding entity, and some assert it was the logical choice to organise and manage the current land settlement entity. Originally, the constitution of Tūhoranuku stated that Traion would have 2 seats within the IMA's board. This allotment was contested, and after some mediation was minimised to 1 seat. Hapu seats within the IMA were increased to 15 from 7, to ease concern from some hapu and claimant groups that hapu did not have a strong enough influence within the proposed IMA. Another concern addressed was the close proximity of Traion to the proposed IMA, so a separate legal entity was created. The IMA has subsequently received their mandate and currently exists as the sole settlement vehicle for Ngapuhi. For some, the continued inclusion of Traion's influence in even 1 seat within the 22-seat board warrants a disassembly and a restructuring of the IMA from the ground up. For these disaffected claimant groups to achieve a mandate and justify either a separate or overriding negotiation, they would need to produce a similarly resourced mandate of the people they wish to represent. This is not a cheap exercise, and many feel the resources required should more wisely be put to use in forwarding Ngapuhi as a cohesive whole, together, in unity. The founders of Tūhoranuku have always held that the Crown is determined to negotiate with one group only for Ngapuhi Nui Tonu, and that by securing the mandate to negotiate, Tūhoranuku has laboured intensively and achieved a significant step in securing a brighter future for Ngapuhi. So is this the case? To answer that, we must first understand how the IMA will operate. The next short video examines how the Tūhoranuku IMA is designed to work.